Hey guys, so here is your vocabulary review for Chapter 1, third set. And this is your final set of vocabulary in the chapter, which means next week you have a chapter test. Woohoo, your first one. And just a quick reminder, please make sure that you actually have read all of your pages to be ready for your open book chapter test next week, because I promise every year it happens, every single year, where students don't actually read their pages, and then when it comes time for the test they don't do very well. So I'm sure you guys have, though. You've definitely read. So here we go. Your first word is crime control model. And the definition is it's a model of the criminal justice process. Politically, it reflects a traditional conservative values. In this model, the control of criminal behavior is the most important function of criminal justice. And there's a lot of different areas and parts of our system that we could discuss at length to use the crime control model as an example or as a comparison, and it would really just take too long in this video, so we will do that in class. But just think of it. Last week, your last word was system, and if you think of the crime control model as a system of criminal justice, it's going to be more traditionally conservative, and it's going to focus on the control of criminal behavior as its main objective. So, as far as our tricks, there's a lot here, because it says right here, the control of criminal behavior, crime control, control of criminal, all right? And the next term is basically the opposite. It's the due process model. And the definition is it's a model of the criminal justice process. Politically, it embodies traditional liberal values. And in this model, the principal goal of criminal justice is at least as much to protect the innocent as it is to convict the guilty. So, I talked last week with your words last week about all the checks and balances and steps that we have in our system to make sure that defendants are given all of their rights, and all of those rights are called due process, your due process rights, and checks and balances to make sure that we're not putting innocent people in prison or jail or convicting innocent people. It is not a perfect system. It has never been a perfect system. We can always try to improve. But in terms of, first world countries or just in general, it's a pretty darn good system. Doesn't mean it's perfect. So the due process model is the opposite of crime control model. We're going to be more concerned with the defendant, the accused, more concerned with the accused getting all of their rights than we are of the crime that was committed. Okay. And again, we can go talk about examples and get into more conversation about these two words when we're in class together. So I'm just looking here to see if there's a trick. An association, due process, protect the innocent is due process. Okay. So your next word, term, is doctrine of legal guilt. And the definition says that it results only when factual guilt is determined in a procedurally regular fashion, as in a criminal trial, and when the procedural rules designed to protect defendants and to safeguard the integrity of the process are employed. And that's a big vague, kind of complicated definition. But basically, it's not enough to be factually guilty. You must also be procedurally guilty. And that means police, prosecutors, judges, everybody has to follow the rules. Because even if there's all this evidence against you, if the rules are broken in your prosecution, then you are not procedurally guilty. And the doctrine of legal guilt says you have to have both. So let me just give you a quick example. Back when we were talking about probable cause and we're talking about warrants, and searches and arrests, you have to have probable cause. Let's say that you need the defendant's DNA to compare it to DNA found at the crime scene. Okay. And you take saliva or a blood sample to get that DNA. And it comes back as a match. Well, I'm simplifying this, but let's just say that proves you are factually guilty. But you were supposed to have a warrant to get that DNA from the defendant, and you didn't. That is a procedural error. That's not procedurally guilty. It's going to get thrown out. And, maybe you've heard of, he got off on a technicality. Those technicalities are the procedures, the procedural rules. And we have a whole body of law called procedural law. And we're going to get into a lot of it in the 2 years in this program. But having a warrant, there are times when you need a warrant and there's times when you don't. And in this example that I just gave you, if you needed one and you didn't get it, that's a procedural error. And that person is likely to, have those charges dismissed or have that conviction overturned, what have you. So the doctrine of legal guilt, you have to have both. You got to have factual guilt and procedural guilt. And our last word, super easy, myths, is our beliefs based on emotion rather than analysis. And another way to say analysis is critical thinking. And again, I don't want to get into it too much right now, and we can talk about it in class, but we are seeing more and more and more in recent times of people believing and acting on things that are based on emotion rather than fact and rather than critical thinking or analysis. And that's not a good way to be. Not a good way to be at all, because there's all kinds of problems that come out of that for yourself personally and from, for the world at large. We have to act on facts, not emotions, and myths are based on emotions. So I said that's your last word. It is your last vocabulary word in the textbook, but whenever that happens, and so you don't have 10 this week, right? You have 1, 2, 3, you have 4 this week. So whenever that happens, I fill in with amendments to make an even 10. Because you're going to need to memorize your amendments. And I know some are tricky and some are easy, some are hard. The First Amendment, and you know what? I'm not going to read this to you. We had it in notes in lecture. I've, at this point, should have shared with you a document that has all 10 amendments on it for your review. And here it is, the exact wording of the First Amendment. And I threw the Roman numerals in there as well. So the First Amendment, Second Amendment, and Fourth Amendment, you probably recall, specifically affects first and foremost affects police officers in their day-to-day activities, what they can and cannot do with citizens on the street. We have not yet talked about the Fifth or the Sixth Amendments, and that's because most of the parts in here deal with courts and law, and we're not in that unit yet. So that's why I haven't given you notes and lecture on these amendments, but yet I put them on your quiz. Whoops. So, the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Well, look at that. You just had those words, that vocabulary word last week. Except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. So, just like our First and our Fourth Amendment, there's a few different parts in the Fifth. And I don't want to teach that whole lesson right now, but you've probably heard of I plead the Fifth, which means you can't be made to tell on yourself. You can't be made to testify against yourself. That's in the Fifth Amendment. I plead the Fifth. And that's what right here it says, where to go? To be compelled, and that means forced, compelled or forced in any criminal case to be a witness against himself. So that's when you plead the Fifth. And there's other parts in here. You know, you probably heard of double jeopardy. You can't be tried twice for the same crime, same offense. That's in there as well as some other things. So that's the Fifth. Do what you can to burn it into your memory. And then the Sixth Amendment also has a lot of parts to it. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, and to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So there's a lot in this one as well. And again, most of it has to do with trials and courts. But again, last week you had some words with like information and arraignment, these processes in charging documents, the right to be informed. Wait a minute. Right here. To be informed of the nature and cause of the accusation. So what are the charges? What are they charging you with? What is the evidence? That's right here in the Sixth Amendment. Speedy and public trial, and again, go back to England and go back to our forefathers and where they had come from and what was going on in their country when they came here. You didn't have a public trial. If somebody accused you of something, you didn't get to defend yourself much. And nobody ever knew whatever happened to you, whatever happened to your case. You got accused of something. The next thing you know, you're going in front of the king, and then nobody ever hears or sees from you again. I mean, I'm simplifying it, but that's kind of what happened. So by keeping our trials, our criminal trials, public, which means any one of us can go to any trial at any time. We just walk right in, sit down, watch, see what happens. Because we think it's really important to our democracy to have open criminal and court hearings and systems. And, you've probably heard, the Miranda warning. And again, I'm jumping way ahead, but you have the right to an attorney. If you cannot afford an attorney, one will be appointed to you, right? That's part of the Miranda. That's right here in the Sixth Amendment. To have the assistance of counsel for his defense. Counsel is another word for attorney. So there's a lot in the Sixth, and we're going to do notes and lecture probably very soon. But do what you can to memorize this. And then the Eighth Amendment, and this is your last one, and it's Roman numeral VIII. Eighth Amendment is in corrections, in our corrections unit, but this one's pretty short and sweet. It says excessive bail shall not be required. Well, you just had bail last week too, and we talked quite a bit about what that word was and what that is. So excessive bail shall not be required, nor excessive fines imposed. So that's one part. And then the second part is nor cruel and unusual punishments inflicted. So we have rules about that. We have rules about what kinds of punishments you can give people. Things have changed a lot over the many, many years. And I don't mean in recent times, although that as well. But if you go back into medieval times, what were some common punishments that you might have heard of or seen pictures of? There's some crazy stuff like being tarred and feathered and being quartered, and they had all these torture devices and just crazy stuff. Well, we decided those were cruel and unusual, so we can't do those anymore because we have the Eighth Amendment who says we can't. Okay? So I went through this really fast. Play your games on Socrative. So let me scroll up here real quick. And you guys, this is your third week of it's fourth week of class, but third week of working in your Quizlets. And so you should be, doing these activities. I'm asking you to do 4 total for the week. 4 games. I don't care what combination you want to do, but you do have to complete the activity to get credit. So do those as many times as you need to so that you've got your words burned into your memory. Okay. Bye.